Hello. Today we are talking a little bit about how to talk to your co-parent, whether ex-spouse or just your child's other parent, during and probably after your custody and family law litigation case. My name is Vanessa Gordon. I'm an attorney with Gordon Law in Lincoln, Nebraska, and I had a conversation completely unrelated to children and parenting with a family member here recently that I thought might be sort of instructive for my clients and any party going through custody litigation. So I've got a cup of coffee here, this one that I picked up from a coffee shop, and coffee is what sort of started the conversation that gives some examples of what not to do. So a family member that I love very dearly was staying with me, and my family's all big coffee drinkers. So this family member came out, woke up a little later than the rest of us, and came out down to the kitchen and had a cup of coffee, as we often do in the morning, and almost immediately began some communication that perhaps is not useful, that we will use as examples here. So the first thing this person said was, "Where's my coffee cup?" in about that tone. And so you react to that how you will. Other statements that were made over the course of the conversation, "I suppose there's no more coffee left." "I didn't get any sugar." "That's fine. I don't expect anyone to think about how I take sugar in my coffee." Okay. "I'll just go down to the gas station like I always have to do when I'm here." Okay. So we can see right away that there are some issues with tone and language. First of all, obviously, if this person is visiting, they don't have a coffee cup that they own. It's our coffee cups, and no one had moved said coffee cup. We had, in fact, considered them and started a new pot of coffee that was in the process of being made. We did, in fact, have cream and sugar available, and had someone simply said, "Hey, do you have any sugar for coffee?" we would have gladly gotten that down. If we needed to help find something or pour something or get something. So I write all this off as kind of a funny anecdote about crabbiness in the morning. Clearly my family needs to not talk to each other until we've all had our coffee, right? But I think that these are all things that could be instructive in how we talk to the other parent. The other thing that I always ask my clients, and really any litigant in a family law situation to consider, is a philosophy that I personally call "we win either way." Right? And that means that we want to communicate with the other side in a way that does one of two things. Either it makes it more likely that the person you're talking to will want to work with you. Now, we don't have control ultimately over the decisions that the other parent or the other litigant or the other lawyer or anyone else in the case makes. We don't have control over that. And there can be a whole host of reasons that they're simply never going to be agreeable. Even as something that seems reasonable to us, and sometimes it's simply that their perspective is that's not reasonable, or it really isn't reasonable in light of something we don't know about them. Okay, so that's one option. But also, not only do we want to speak in a way that might make them be a little bit more, or cause them to respond a little bit differently, or help them respond a little bit differently, but we also want to look at how we're building our case. If the court sees, hears, or reads the communication that's occurring, how will the speaking person come across? So you want to be aware of that, because nowadays with cell phones, it's very possible that absolutely everything you ever say or do or write or read, all of that can be before the judge at a trial at some point. So when speaking with your other parent, you want to watch first and foremost for your tone and language. Okay, that doesn't mean to be fakey nice. If you appear condescending or over the top, judges can see through that as well, and that also can have the opposite effect of being somewhat offensive, right? But you do want to be respectful, polite, non-accusatory, right? Recognizing that there may be another explanation other than what might be in our heads. Sometimes there's not, but sometimes there is. You also want to avoid, along with accusations, you want to avoid conclusions or assumptions. You don't want to assume that no one thought of the fact that you put sugar in your coffee. You don't want to assume that the parent will be late like they always are, or that they're going to cancel their Saturday like they always do. Even if we know that in the back of our heads, and we're making a backup plan for that, we don't necessarily want to say it that way. Both because it's non-helpful for trying to get some compromise or accommodation from the other side, but also because when the judge reads that, we want to come across as open, friendly, rational, reasonable, and focused on the children. Okay? So that's the other thing. We want to stay focused on the children and on the matter at hand. So when we're asking about switching one Saturday in Memorial Weekend, for example, we don't want to bring up every other year that has ever happened. Your job is never to argue with the other litigant. Your job is never to argue with opposing counsel. Your job should be to simply ask for what you're asking, or state the thing that you need to call attention to, right? And then stay on the topic and focus on the child. And then you want to also be aware of requests versus demands. Okay, a request is something the other side does not have to give you. They do not have to switch their court-ordered parenting time with you, no matter what the reason is. They don't have to. And so we don't want to go in and say, you will switch, deal with it, right? And even when you have the power of right or the power of law, or your parenting plan says, hey, this year it's an odd numbered year, I get to determine what my summer dates are first. You don't necessarily have to phrase that as please, oh pretty please, but you do need to say, hey, looks like my dates are due to you by May 15th. It's May 10th. Here are the dates that I'm looking at. And kind of putting it that way. You're standing on what your parenting plan says, but you're also not demanding it, at least not initially. If you get some clapback and you need to say, hey, I have first choice this year, I'm sorry, but you're just going to have to make other plans. That's reasonable after you've given them an opportunity to come up to doing what they're supposed to do. So, and then the other thing is when you do hit a disagreement, you want to seek to understand first. And that's the Stephen Covey's, 7 Habits of Highly Effective People. You want to understand what the reason is. So, for example, maybe in blended families, there's a reason that we have a stepchild's graduation or step sibling's graduation, or a health issue of an in-law, or something along those lines that could be a rational, reasonable reason to maybe make some adjustments. Maybe there's a job change on the horizon you don't know about, all of those things. So you just really want to take a moment. I think for myself, there was a moment where opposing counsel had asked to continue a trial that had been planned for several months. And I, unfortunately, maybe without thinking about what could be the reason, had kind of responded angrily about a request to continue that turned out to be due to a death in the immediate family. And so obviously that was a reason that it was just, it's frustrating, but it's beyond anybody's control. Certainly opposing counsel didn't ask to have a death in the family. And so we want to be aware that sometimes there's these things that happen that simply are not avoidable. And we don't want to seem like the irrational, unreasonable, angry person who can't have human kindness in those circumstances. That gives the judge a different impression of you, even if that's not who you are, right? So you really want to bring your best self to litigation, just like any other job or any other project that you're going through, okay? So the top things to remember are tone and language, staying non-accusatory. Remember, you win either way if you simply stay non-accusatory in your communication and then develop the facts, the documentation, the exhibits that will show that what you wanted to accuse them of is true. That's a much more effective way in litigation than simply saying, a lot of litigants assume if you say, well, you always or you never, that the court's going to understand your position. And that's just not how it works. You have to show that pattern in a non-biased, black and white sort of way. And then staying, if you're making a request, clarify that it's a please, clarify that it's a thank you, be polite about it, If you are even making a demand because you're standing on something that's already been court ordered, you want to do that firmly, but you want to do that kindly. That will have a much better outcome for you if it were to come up in court later. Focus on the child, focus on the matter at hand, staying on topic, and then seeking to understand before you react. It's very hard to do. The law is reactive, it is not proactive. So things have to happen before the law will do something about them. So recognizing that, you also want to slow down your reactions a little bit and make sure that there's not an alternate explanation that would destroy your case. So if you keep these things in mind, you will find that both your frustration level going through the litigation process and your frustration level in dealing with someone that you otherwise maybe wouldn't have to anymore will help come down, and that will help you stay in a clearer place of mind. The other way that it will help you is that if those communications do get before the court, often if you have one spouse or one co-parent that can be rational and reasonable, and the other side cannot, the court, being human and recognizing that, will often have a different impression and give more credibility to the party that appears focused on the children, appears focused on the matter at hand, appears to understand when it is not reasonable or rational to react in a certain way and to maintain that maturity. And so those are all things to consider when you're communicating with the other side of your parenting situation. I hope this is helpful to you, and I hope that if you have a Nebraska family law case, you would consider or recommend Gordon Law.